After the end of the Second World War, certain efforts were made to ensure basic rights of man. Certain charters of an international scale were signed in order to bring out the questions of sufferers and those who inflicted suffering, in order to declare what are the rights of man as human being, as human creation. And the court will see, on the basis of the documents referred to by me, that in this effort to ensure human rights to all men all over the world, this was done systematically, and there was only one exception in all these efforts: criminals of war. The right to bring them to justice had been given clearly. And it is stated in all, though it's not yet stated, it is stated that all, in spite of all that has been said in those charters, it is possible to bring them to justice on the very basis of these charters. And the basic declaration is the declaration to all men with regard to the rights of man, the Universal Declaration of Human Rights. I'm going to read now from the official publication of the United Nations. Which had been translated into the language of all the member states, also into Hebrew, with the emblem of the United Nations. The principal rights of freedom from imprisonment had been clearly stated in this charter. Please proceed. The equality principle had been determined. The principle of fair and public justice had been ensured to every human being. But what has been said in paragraph 11.2? Nobody is going to be charged with a criminal offense for commission or omission of an act which were not considered as crime at the time of omission or commission of the act by the international or national law. In the essential declaration of the human rights, humanity took upon itself the task to punish the crimes against the international law and to punish people, not states, to punish individuals, not groups of individuals. The principle of personal individual responsibility, I'm going to deal with later in detail, had been established in this principal charter, which gives rights, but it doesn't only impose rights, it gives also duties. Men, human beings, have rights such as principles of freedom, but there are also duties incumbent upon them, duties to act in accordance with the rights of justice, and who is going to flout these duties is going to be brought to justice for the infringement of international law. the European Charter,
the European Treaty for the Rights of Man,
Convention for the
Protection of Human Rights and Fundamental Freedoms, from which I quote,
This is
a report, report prepared by the Commission for International Law. What happened to this report? The United Nations were busy since 1950 up to 1961 with urgent matters, and this report was put off from one agenda to the other and is still on the agenda of the United Nations Assembly. But as far as the execution of those principles laid down, the Commission set a commission including jurists of all over the world and laid down clearly
expression of the revolutionary change which has taken place in the political situation of the Jewish people. While other peoples legislated laws soon after the end of the war, and some even before the end of the war, with regard to the bringing to trial of Nazis and their collaborators, the Jewish people, who has a very long account to settle with the Nazis, was deprived until the establishment of the State of Israel of political authority to bring to trial Nazis or their collaborators. Nor did it have any authority to demand the extradition of such people as becomes possible under the proposed law. The judge asked what volume of the Knesset proceedings is this to be found. This is in volume 4, the prosecutor replies, on page 1147.
Nazi law, Nazi collaborators.
In accordance with this law, they have been brought to trial before Adolf Eichmann a number of people since 1950. In the State of Israel. And punishment has been imposed, and quite severe punishment, not only upon Nazis, but on Nazi collaborators. And even those who carried out the orders of the Nazis, though they might have been Jews. To the extent that they could not find adequate defense as persecuted people, and to the extent that this wicked regime deprived them of their moral conscience and were subsequently found guilty and punished in accordance with the law. The judge asks, why does the Prosecutor General quote these cases? He replies that this is how the court should look at the law which is passed in the Knesset of Israel. I quote from a criminal appeal arguing yesterday, the counsel for the defense described what he thought were the purposes of our law, and if I understood him correctly, he argued that if one is to speak of reparations or atonement on the part of the accused, one should bring him to trial in Germany or in another country. He also stated that the accused by himself cannot atone for all the acts of his country. The atonement, so stated the counsel for the defense, must come from the state which sent him to carry out these crimes. The accused was dragged along not through any fault on his part to inherit the results of these crimes. He will have to prove this last argument, and the time will come when we shall deal with it. For my part, I would like to say at this juncture that our argument is that Adolf Eichmann was not just an ordinary cog in the wheel, and we shall attempt to prove to this court that he initiated, planned, organized, and implemented the extermination of the Jews in Europe. I agree that this is a factual argument on which there is a dispute with the counsel for the defense. I have not yet reached the point of proof, but the counsel of the defense too has not yet proved what he says, and therefore, from the point of view of this factual argument, this is not sufficient for your honors.
This cannot be brought into account when preliminary arguments are brought before the court. This is not a repentant come to Canossa to atone for crimes, for moral crimes. The accused is a man accused for committing crimes, and his personal responsibility for those crimes was read out when other war criminals were brought to justice at Nuremberg and in other countries. In the paragraph which I wish to quote. And I believe that I understood the defense when he said that Germany already atoned, already expiated. You received reparations. What else do you want? I wish to say and stress that the agreement for reparations did not come to atone or pardon and not to help to forget. The crimes have no atonement. There is no pardon and there can be no forgetting. It is only possible to hope and believe that the sons will be different from their fathers and that new generations will grow and a son will not be called upon to give judgment for the sins of his father. But he who committed those crimes, to him there is no pardon and there is no atonement. The Jewish people remembers for 2,000 years now him who tried for the first time in history maybe the crime of genocide, Eichmann. The Jewish people will never forget the one who succeeded in part to commit this crime. Mr. Hausner, how much more do you need for your pleadings at this stage? I believe I shall need the whole day. And will this be enough? Maybe tomorrow we are not sitting. I shall need 1 hour more on Friday morning to reply to some of the arguments, the written arguments which we studied last night. Besides, I need the whole day today. We shall adjourn now for 15 minutes, up to 20 minutes. Will the witnesses approach, please? Mr. Tohar and Mr. Shimoni, please. You are informed that you are... Will you please rise? You are free until Monday, till next Monday, and as from Monday you will be at the disposal of the court on a 3 hours telephone call which might be given you, and you are free for the day. Please leave your telephone numbers to the secretary of this court. This is all. Thank you. Judgment given in Philip against Eyre, and the judgments brought in that case speak in favor of those laws questioned by the attorney. What Mr. Justice Wills says on page 27 can be summed up this way. although retroactive legislation is not to be recommended, it should not be declared that it is always unjust. There may be circumstances, the security of the state, which necessitate retroactive legislation, because the ordinary laws made for ordinary circumstances and for the peaceful life of the community cannot satisfy the demands of justice and fairness. 2. The decision in this question, if circumstances demand such retroactive legislation, is in the hands of the Parliament and not in the hands of the courts. It is not the duty of judges to examine the necessity for such legislation. I am of the opinion that these words include the answer to the contention made by the defense. May I be permitted to cite and to draw your attention to an article by Sheldon Glick in Harvard Law Review, volume 59, page 396. The name of the article is The Nuremberg Trial and Aggressive War. And I shall cite 2 paragraphs. First, on page 443.
That which Hitler and his clique did not know was that while they would be given every reasonable facility for defense, they would not be permitted to escape personal liability by hiding their flagrant deeds behind the protective mantle of the convenient state. Is their ignorance of that suddenly to transform them into innocents, whose prosecution is frightfully unjust and fatally illegal and obnoxiously ex post facto, because it involves something of which they had had no prior notice?
And on page 428, international law. And I request to reject the argument that the court is not competent to sit in judgment because the indictment is drawn up according.
It cannot be applied in war crime trials where the ends of justice would be violated by its application.
Therefore, I request to reject the argument brought forward by the defense that our law is contradictory to the principles of international law. And I request to reject the argument that the court is not competent to sit in judgment because the indictment is drawn up according to a law opposing this principle. On the contrary, the law gives expression to the most worthy principles of doing justice. The second argument for the defense is the accused did not commit the crimes on your territory. He did not violate the right of your citizens or your state. You were not in existence when the crimes were committed. Therefore, you have no right whatsoever to try the accused, and this because of two reasons. First, because he was brought here against his will. Secondly, because your law, which claims to be an extraterritorial law, contradicts on this point the principles of the law of nations. I already answered to the first argument, and I only wish to divide clearly between two different reasons which I believe got mixed up in the words of the defense. There is no connection whatsoever in the matter of bringing a man against his will to the jurisdiction of a court in a state and between the question of extraterritorial law. If we, for a moment, agree that our law has no power because the law is extraterritorial,
בספרות האמריקאית אומרים אקס, באנגלית אקסטרה, אבל אם בית המשפט מעדיף אקסטרה, אני ברצון אעשה זאת. אם באמת החוק שלנו,
if our law is invalid, then even if the accused is brought here of his own free will and not by force, even then one cannot try the accused if the law is not law, if the law is invalid. And if the bringing of the accused against his will invalidates the jurisdiction of this court and the competence of the court, it also invalidates the jurisdiction regarding all laws, ordinary laws, not necessarily extraterritorial laws. Therefore, one must separate the two arguments, and there is no connection whatsoever between the two. The defense spoke of the two together, but I request the court to discuss each argument separately because they touch upon different and various principles of law. To the question of bringing a man by force, the question of bringing a man against his will within the jurisdiction of this court, I have already replied yesterday, and I shall not repeat my words. I therefore touch upon the other part of the argument, trying to invalidate our law because it deals with acts not committed not committed in Israel, and at the time Israel did not yet exist. The principles giving a court the authority to try for criminal offenses were promulgated before the Second World War by known American jurists in a research work conducted by the University of Harvard. Not bring into account the place of committing the crime and not the nationality of the victim. It is also worth to point out that in a number of those trials the principle of passive authority overrided the principle of territorial authority, even though the place of committing the crime was in the country of an ally: France, Norway, Holland, Belgium, China. And now a number of clear examples and instances of universal competence of a court given to American or British courts. Is it really necessary, Mr. Hausner, to read out all those excerpts? I see you have 2 more pages to read, and the court will receive the volume. A British military court, which sat in Holland, in Almelo, convicted a German on 2 war offenses committed in Holland, the one against a British war prisoner and the second against a Dutch citizen. One of the accused was convicted on the last offense, only on this offense. In a matter brought before the military court in Hamburg, the crime was a collaborator in a crime, although the place where this collaboration took place was Hamburg. The crime was actually committed in Poland. The victims were
witnesses and evidence be the most convenient locus in which to try a war crime, there is no reason why that state should not perform that function.
The state of Israel, your honors, from the point of view of the Holocaust of the Jewish people, from the point of view of the very existence of the witnesses, the witnesses from among the survivors, the embers of the Holocaust,
this is a source of information. The existence of an institution like Yad Vashem, collecting all historical data, and other institutions of research for the research of the Holocaust. This is the place fit and suitable also according to this principle to try a man accused of such crime.
In the book published by the University Publication of California, till the committee decided upon the drafting as it appears now. Please submit it together, says the judge. We are told, bring Adolf Eichmann before an international court. What international court, may I ask? International Court of The Hague is dealing with conflicts between state and state and has no jurisdiction over individuals. The International Military Court, on the other hand, which was sitting in Nuremberg, had wound up its activities and is no longer in existence. I didn't understand the claim here that there is an international court that made it. All right, I'll bring that point in a minute. Also, the International Court, which was sitting in Tokyo and was dealing with war criminals, does not exist anymore. So what should the State of Israel do? To ask the United Nations to set up a special tribunal? Already in Tokyo. At the time when there was already a honeymoon, so to say, there were already difficulties with regard to the trial of war criminals among nations. Do we believe that the project now of setting up an international law court today is possible without any complications connected with Cold War and all the other international conflicts? Would it be possible in this atmosphere, in this climate, to set up an international court of justice? To whom should Adolf Eichmann be delivered under the circumstances? To the Poles, to the Hungarians, to the Czechs? Yes, of course, he also perpetrated crimes against them. But the very essence of his crime, the strongest and the most blatant and glaring, was the crime against the Jewish people. The State of Israel wanted the setting up of an international criminal court. We made considerable efforts and numerous efforts in our appearances on the arena of the United Nations. In 1951 and 1953, we did all those efforts so that such court be established. As a small state, we are interested in a supreme body whose task it will be to defend the weak and the humble. I'm going to bring to the court the reports of the committee. Committee on International Criminal Jurisdiction. The proposals of the State of Israel in this respect. Whose committee? This was the Committee of the United Nations, the answer is. It was attached to what body of the United Nations? To the General Assembly is the answer. And perhaps I may be permitted to recall here that Dr. Robinson, my colleague, was one of the most active delegates at that very committee in favor of the establishment of the Criminal International Court of this kind. But he couldn't succeed because the great powers didn't want a court of this kind. And today there is no international criminal court which might deal with the matters similar to the one at hand. Today, only one of the countries in accordance with its domestic law can try Adolf Eichmann. In this respect, what was the end of the deliberations you referred to? Was there any conclusion of the deliberations regarding the establishment of the International Court? Answer, there is a report and there are recommendations. And the matter has not as yet found any solution. Is this on the agenda? Yes, it is on the agenda of the United Nations Assembly. I didn't hear.
May I request that the two reports about the rights of men and the competence of criminal courts, that copies be handed to me. I hope I'll be able to get further copies from the Foreign Office, and I shall hand them over to Mr. Servatius, to Dr. Servatius.
Who spoke in German now? So how could he say that he's handed over to Servatius? That you did the Hebrew translation.
As the court will see by reading the indictment, Adolf Eichmann is accused, first and foremost, under an offense against the Jewish people. The Jewish people is not only in Israel. There are Jews outside Israel, larger and smaller congregations living under the laws of other countries. But the only state in the whole world which is a Jewish state, as declared by the state itself in the Declaration of Independence, as recognized by decisions taken by the United Nations, and a state which has sovereign Jewish institutions is the state of Israel. It is the privilege of the Jewish people for national revival has been declared at the Zionist Congress in 1897, at the first Zionist Congress. In the year 1917, the Balfour Declaration was made and spoke of a Jewish national home, and the mandatory which was given to the British over this country included this declaration. And the historical connection between the Jewish people and the land of Israel was recognized by the law of nations. The national home, which was begun during the British rule, was meant for Jews. Also for those millions who are no more with us. And if any state feels on its own flesh and blood the results of those crimes, it is the state of Israel first and foremost. the manpower, the belief for a Jewish state. This was a state in the making, not only here, but there too, in all those countries where the Holocaust came and exterminated our people. And the Jews there were waiting for their state. In the year 1936,
those parts of the world which tend to grind down the Jewish community, make it the flotsam and jetsam of the world, grind it into economic dust, so to speak. Though it is generally known that the position of the Jewish people is not a very happy one, I think it is too little appreciated what its misery is, and that is why I have permitted myself to dwell on it at some length. After all, it affects the fate of 6 million people.
These were the 6 millions who existed then at the time when Weizmann spoke, and for whose sake he requested the setting up of the Jewish state, and they are no more with us. Who more than the Jewish people, from the point of view of the consequences of the Holocaust, feel this terrible vacuum which has been created within the Jewish people? Who can compare with us in authority to sit in judgment in view of what has happened? The Jewish community in Palestine in the pre-state period was the only one which could become
gone French Indochina. The locus delicti commissii was French territory. The victims were United States nationals.
So we see that the British military court in Singapore judged a Japanese war criminal for a crime committed on French territory against American subjects. And the origin of the authority of this British court, this is found on page 53 in the Hadamar trial.
The United States did have a direct interest in punishing the perpetrators of the offense, inasmuch as the victims were nationals of allies engaged in a common struggle against a common enemy.
Your Honors, if British or American could sit in judgment for crimes not committed on their own territory and not their subjects were the victims, they had no interest whatsoever in the whole case, and only because the victims were allies, the more so it is the privilege of a court in Israel to sit in judgment on a man accused with the intention to exterminate the Jewish people. The Jewish people to us is not an ally today, and maybe and may not be an ally tomorrow, political or economic. Today an ally in war, and tomorrow may be an enemy. If they could sit in judgment and be competent to judge because the victims were allies, our right is moral and legal to try a man who tried to exterminate the Jewish people of our flesh and blood. And no one will question this right and authority. Mr. Hausner, is this the place to mention regarding Czechoslovak, Polish and other citizens and subjects who are also victims according to the indictment and are within the definition of allies? Your Honor, we accused Adolf Eichmann under the offenses known to us, and since a crime against humanity in our opinion is extraterritorial, we are authorized to try him in the country against Poles, Gypsies, Slovenes, Romanians, as a Polish, a Hungarian or a Czechoslovak court was competent to try for crimes committed against their own subjects and subjects of other countries. When a Polish court of law set in judgment on Rudolf Hess, the commander of the Auschwitz camp, it set in judgment on a man for crimes committed in Poland, that is true, but against subjects of a dozen of countries. And even more, Your Honor, if we do not try this man, if this court of judgment accepts the argument brought forward by the defense, it is quite possible that he will not be tried at all, and the crimes without precedent which he is accused of may pass scot-free. I already said there is no state at the moment demanding the extradition of Adolf Eichmann. There is no state demanding the right to sit in judgment on the accused. And if this court will forego the right and authority to sit in judgment, we shall have to set him free. And if he returns to the Argentine wherefrom we brought him, how can he go back to the Argentine? He lived there in a different name. The Argentine did demand his return when the discussions were on. Were we to return Adolf Eichmann to the Argentine, maybe that Ricardo Clemens could come out from his hiding place if all he was afraid of was extradition and not any other harm. For according to the law in the Argentine, as I will prove to this court, he was immune of extradition to any state. except matters covered by an agreement for extradition. It has been decided in a court in the Argentine that the Argentine will not extradite a war criminal after the period of lawful prescription of 15 years has elapsed, which is the Argentine law regarding war crimes. Regarding a case heard in Buenos Aires in the 18th of June 1960 at the request of Czechoslovakia to extradite Dolchansky, the court refused to grant the request. And this is what the court says, the Argentine court. The decision must be taken according what is the law and what is the period of prescription. The extradite law